Good morning. We are going to get started here. Thank you for joining us today. This is another edition of Breakfast Briefs. This week, we're going to deal with bankruptcy protection for businesses and how to avoid it. Last week, we dealt with personal bankruptcies and strategies to avoid filing a personal bankruptcy. I'd invite any of you to visit us on YouTube where you can view that presentation if you missed it. This week, we're going to be dealing with businesses and some strategies on how to avoid a bankruptcy and other types of bankruptcies. We're going to we have a great panel before us today. Tim Hughes, Steve Magala, and Josh Nesser. Lavelle Law, we are a full-service law firm. We handle a wide range of different legal work, including corporate, transactional, commercial litigation, estate planning, real estate, labor law issues, family law, and of course, we also handle bankruptcies and business workouts and other ways to deal with debt problems, debt issues. So let's go ahead and get started. Today, as I mentioned, we're going to be handling different types of bankruptcies. When you talk about bankruptcy, they typically fit in one of two different categories. First of all, before I forget, I apologize. If you do have questions, I would invite you to submit your question in the Q&A prompt on the Zoom platform. We will be answering those questions as best we can at the end of the presentation. So as they occur to you, go ahead and type it in, and then we will address those questions as best we can at the end of the presentation. Okay, so just as far as perspective, when we start talking about bankruptcy, typically they fall in one of two different categories. On one end, you have a liquidation. A liquidation would be a way to terminate the existence of a business. Typically, it's known as a Chapter 7. The other type of bankruptcy is a reorganization. A reorganization, you're not ending the life of the business. The business is going to continue to operate. You're going to, the business is going to continue to operate, see business, see customers. The difference is you're going to restructure your debts, and that restructure is going to give you more time. So you're going to save the business. That's the hallmark of a reorganization. When you start getting into terminations or liquidations, there's, the Chapter 7 bankruptcy, as I mentioned. In addition, there's a dissolution procedure that we will spend a little bit of time talking about, state law dissolutions. And then in addition, there's an assignment for the benefit of creditors. That's another type of ending the existence of a business. We'll spend a little bit of time on that. Now, if you're a business and you're dealing strictly with tax liabilities, in particular employment taxes, we're going to talk about some strategies to deal with that. You may not need to end your business. You may not need to file a bankruptcy. There's some strategies that you can use if you're only dealing with taxes. And Josh Nesser will talk about that. Okay, so bankruptcy overview. Chapter 7 liquidation, I'm going to talk about that. Chapter 7 is a liquidation. It's a termination of the business. The bankruptcy is commenced when the business files a bankruptcy petition with the bankruptcy court. The petition is signed under penalties of perjury, and you're going to list all of the assets of the business, and you're going to list all of the liabilities. In addition, you're going to submit a statement of financial affairs. That is a statement where the debtor discloses to the bankruptcy court and the trustee certain business operations over the past 12 months. You're going to disclose certain activities, certain payments, certain transfers. Other disclosures are made in the statement of financial affairs, and we'll spend a little more time talking about that. Also, Chapter 7 liquidation. The assets are going to be liquidated, and that is a job that is appointed to the United States trustee. When you file the bankruptcy petition, the bankruptcy court will appoint a trustee. Upon the filing of the bankruptcy, the business really stops operating. The business should no longer be dealing with customers, should no longer be distributing assets, paying off creditors. At that point in time, when the petition is filed, the bankruptcy court will appoint a trustee, and it's the trustee's job to wind up the affairs of the business. And that phrase, winding up the affairs, that means collecting any outstanding claims of your customers. If there's outstanding receivables, that trustee, it's his job to try to collect those receivables. If there's other claims of the business against other parties, that trustee could file a lawsuit on behalf of the bankruptcy estate to try to collect those assets. If you have physical, tangible assets, the trustee, it's his job to sell those assets. The trustees, it's his obligation to try to maximize what the trustee can get out of the sale of those assets. And whatever he receives out of the sale of those assets, that becomes part of the bankruptcy estate. In addition, the trustee will have notice sent to all of the creditors of the business. Creditors will be receive their notice. Creditors will have a period of time with which to file a proof of claim. Now, it's also the trustee's job to try to determine, are these claims legitimate or not? If a creditor files a claim, it's possible that the creditor could be claiming amount owed to it more than what is really due to the creditor. So if that takes place, it's the trustee's job to try to really find out what is due to the creditor. And if the creditor is asking for too much, or the creditor is really not doing any money, the trustee could object to that claim, and there could be a procedure filed in the bankruptcy court between that creditor and that trustee to determine whether or not that claim is legitimate or not. Now, that's a procedure that's between the trustee and that creditor. The bankrupt debtor, the officers of the company, or the shareholders, they don't really have to spend money to try to fight that fight. That's something that is handled by the trustee, and the trustee uses the assets of the bankruptcy estate in order to wage that battle against the trustee. Okay, in every bankruptcy, there is a creditors meeting. Creditors meeting is a meeting that's conducted by the United States trustee, and a representative of the debtor has to attend. Usually that's the president or some other officer in the company, somebody that has knowledge of the financial affairs of the business. And in addition, creditors they also have a right to attend that meeting. Now, ordinarily, these meetings are actually rather short. They're usually 5 to 10 minutes in length. If there's a lot of issues that the trustee wants to deal with, the trustee could continue that and hold that meeting at another date, but the initial meeting is usually relatively short. Quite often, the trustee may have several meetings scheduled at the same time, but like I said, a trustee, if they need to, they can always continue that meeting to another date where they spend more time with that debtor over those issues. Now, the purpose of the meeting is the trustee to try to ask questions of the debtor to find out about the assets of the business, find out about the operation of the business, and learn about what happened. And the trustee's really trying to gather information that they can use in order to maximize that bankruptcy estate and or possibly object to any claims that are not legitimate. Now, I've been using a phrase a little bit ago, the bankruptcy estate. As I mentioned, it's the trustee's job to try to maximize that estate. And so as I mentioned, obviously they're going to be liquidating assets, selling assets to raise cash on the sale of those assets, but there's a couple other concepts you have to understand as well. Preferential transfers, okay, so that's a phrase that you'll see a lot in a business bankruptcy. So the bankruptcy code has a concept where they want to treat like creditors the same. And the way they go about accomplishing that is that they give the trustee some tools with which to claw back to the bankruptcy estate certain transfers that were made within 90 days of the filing of the bankruptcy petition. So, for example, if you're running a business and you're going to file a bankruptcy and a week before you send $50,000 to pay off your uncle creditor and satisfy his claim, and then you file the bankruptcy the next day, that would be considered a preferential transfer where the trustee would have the power to make your uncle pay that money back to the bankruptcy estate. Now, that doesn't mean that your uncle is not going to get paid, but what it does mean is that he has to file a claim like any other creditor, and his claim will be treated in accordance with the bankruptcy code. The next concept, payment to insiders. An insider is anybody that has control over the affairs of the business. Commonly, it would be major shareholders or officers or directors of the company. The debtor has to disclose payments to these insiders that took place over the last 12 months. So if perhaps maybe 6 months before the company filed a bankruptcy, if it distributed profits to the shareholders, the trustee may attempt to try to recoup and claw back that distribution of profit back to the bankruptcy estate. Another concept, liens on assets. If you have an asset, the business has an asset, and you may have borrowed money from a bank in order to acquire that asset, or maybe you borrowed money from a bank for a line of credit, those creditors quite often will file a lien on assets of the company. And if that happened, if that took place, and that lien was properly recorded, it's a legitimate security interest and has a lien on that asset, then that asset is no longer part of the bankruptcy estate. That creditor has a right to take that asset and foreclose its lien on the asset and recoup whatever they're owed through that particular asset. That's one of the reasons why if you're ever in a situation you're going to lend money to a business, it's very good policy to obtain a lien over those assets, because if you do that, you become a secured creditor. And I mentioned earlier, the bankruptcy code wants to treat like creditors the same. Well, the bankruptcy code has certain different categories of creditors. As I mentioned, secured creditors, they are at the top. You also have priority creditors, which would be creditors like for the IRS, governmental creditors, certain wage claimants may have a higher preference, and then usually at the bottom are unsecured creditors. So that's another concept under on the liquidation of the bankruptcy estate. Okay, at this time I want to shift gears, and we're going to move the discussion on to reorganizations, and Tim Hughes is going to deal with that particular issue. Tim?
Thank you, Ted. Morning, everyone. Ted was talking about a Chapter 7, which is a shutting down of the business. Sometimes management will say the business is viable and needs to remain open, but we can't deal with a particular creditor or creditors because of their advantage in court or some other basis. So a reorganization under Chapter 11 allows the debtor, the business, to address all the creditors. Ted had mentioned in the Chapter 7 that the entity files Chapter 7 petition and schedules, and then it's kind of the trustee to administer the estate. In a Chapter 11, the business is now going to propose a plan to address all its creditors. Creditors that are secured, that have assets that the debtor wants to keep. Creditors that are secured that the debtor doesn't want to keep those assets, priority and non-priority, and general unsecured, and then there's administrative expenses in the Chapter 11. The typical length of a Chapter 11 plan is about 5 years, and the benchmark for having a successful plan is the liquidation analysis, that the debtor, the company, has to propose a plan that is better than what everyone would get if they filed Chapter 7. Because why is the court going to waste resources and allow for a business to get bankruptcy protection under an 11 if it's not doing any better than what a Chapter 7 would provide? So the Chapter 7 liquidation analysis is typically the minimum requirement for a successful plan. But again, a Chapter 11 can sometimes be filed to allow for an orderly liquidation. A creditor, IRS, Illinois Department of Revenue, or some judgment creditor has a lien or a judgment that they're going to try to enforce, and that will shut down the business. So the business says, we're viable. If we have time to market our business, we can get a lot more than what we could get through a judicial sale. So sometimes an 11 is filed knowing that it will lead to a liquidation, but it's a liquidation that is being kind of driven by the business and not outside forces. And again, the reason for that liquidation may be because of the mix of priority and non-priority creditors in the mix of claims that the debtor has. Next slide, please. And the more typical reason for the 11 is to save the business, that it is a viable business, but for one creditor or two that have taken advantage or have the ability to shut down the business at an inopportune time, or that the business just recently faced events outside its control, but once it gets beyond that, restructuring debt will allow it to move forward and be a successful ongoing concern. So the Chapter 11 allows the debtor to propose a restructuring plan to address the secured claims, address the priority, address the general unsecured. Next slide, please. Chapter 11s typically are very difficult for smaller businesses to successfully complete because of the many hoops and hurdles in a, call it, full-blown Chapter 11. There's a small business version of a Chapter 11, but it had a lot of the hoops and hurdles that the full-blown Chapter 11 had. And in 2019, the Bankruptcy Code was amended to allow the Small Business Reorganization Act. It became effective in February of 2020, 180 days after the president signed the act. And the act being in effect in February of 2020 was then tweaked by the CARES Act because of the COVID crisis by increasing the debt limit. Before, the debt limit of a small business reorganization was $2,725,000, and now it's been increased for 1 year from March 27th to March 27th, 2021, to allow for debt of up to $7.5 million. And the debt is for a debtor that has business or commercial activity. That may not necessarily have to be ongoing business or commercial activity. A recent case in South Carolina allowed an individual who had signed personal guarantees for 2 closed LLCs to file a Chapter 11 Subchapter 5 small business reorganization based upon those personal guarantees on 2 closed businesses. But typically, we're looking at the Small Business Reorganization Act of 2019 to allow for a business to move forward because of the simplification of the Chapter 11 requirements. Next slide, please. The Act has a timeline that is a little more simplified than the full-blown Chapter 11. A petition still has to be filed, like in the full-blown 11 or the Chapter 7 that Ted had mentioned. The filing of that petition creates the automatic stay that stops all creditors, and it gives the debtor in the Subchapter 5 90 days to propose a plan. Ideally, the debtor would be trying to market the plan prior to the filing to have a consensual plan to propose to the court that creditors have agreed on. But if that can't be done. The debtor has 90 days to propose a plan on addressing all of its creditors. Unlike the full-blown Chapter 11, the Subchapter 5 does not require a new creditor or a creditor committee to be appointed. That's a cost savings for the debtor, and a similar cost saving is there's no quarterly fees to the U.S. Trustee's Office based upon expenditures. There's no new setting up of bank accounts with the designation of debtor in possession. And the current owners of the small business can remain the owners of the small business through the Subchapter 5. Next slide, please. Another advantage of Chapter 11 is in dealing with commercial leases. As somebody will be talking later about non-bankruptcy alternatives, you can always renegotiate any contract, whether it's a supplier or a lender or a landlord. But the Chapter 11 filing creates rights and pressures that may allow a debtor to be able to take advantage of the bankruptcy filing to renegotiate a lease. The Bankruptcy Code does not force a landlord to renegotiate a lease, but the economics of my client hasn't been paying because they've been saving money to pay for their bankruptcy attorney, but now they've filed bankruptcy. Under the code, once the debtor files, they have to resume making those leases that they are contractually bound to. However, they've got a 120-day period in which to assume or reject. There's not a mechanism for enforcement for the landlord to get the post-petition payments other than the landlord hiring their attorney to go into court for a rule to show cause, which will maybe highlight to the judge that the debtor's case is not that viable. But the landlord or the tenant can then negotiate with the landlord saying, if I surrender or reject your lease, then all the amounts due become not a lease that's been assumed, but a lease that's been rejected, and will get paid out as a lower price or a lower portion of payments. So that ability to kind of terminate the lease through rejection of the lease is a powerful negotiating tool. And with guarantees, that can be part of the negotiating, whether it's just the debtor that is getting the modification benefit or all parties to the lease. Next slide, please. Another use for the Chapter 11 is if the IRS or Illinois Department of Revenue or any state agency is using their ability to levy bank accounts or assets. The filing of the Chapter 11 can put a stay on those activities and force a payment plan that the IRS or Illinois Department of Revenue may not have been agreeable to. Again, the liquidation analysis will help the debtor show the taxing body or whatever entity that's filed the bank levies or citation, here is my financials, here are the assets that would go to you if this case were converted to a 7. My proposal is that you will get more than what you would get if we closed the doors and filed a 7. So therefore, the debtor, while having to pay costs in the 7, or I'm sorry, the Chapter 11, will be able to keep the doors open and make a better payment plan to the IRS than the IRS revenue officer would be trying to collect on. Next slide, please. Another advantage of the reorganization is the ability to cram down a lien, that an asset, because of obsolescence or whatever market conditions, is now no longer worth the value that the secured creditor has on that asset. So the debtor can propose a plan to strip down or cram down the balance and pay a portion of that balance as secured and the remaining balance as unsecured. And this kind of pennies on the dollar goes to the general unsecured. Priority creditors will get paid in full. And one caveat on this is if there's a critical supplier, that vendor may be needed post confirmation. So they may be needed to get a higher percentage or full paid than some other general unsecured creditors. So there has to be an analysis of, is there another supply line for the business or other vendors that can provide that, or can something else be worked out with that particular creditor? Next slide, please.
All right, Tim, thank you for that presentation on reorganizations and subchapter 5. We're going to shift gears a little bit, and now we're going to deal with borrower and tenant workouts in the commercial leasing area. Steve, you want to take it away?
Sure thing. So yeah, this topic is borrower and tenant workouts. So obviously it's pre-bankruptcy, and so we're dealing with leases and loan documents. And really all parties, when they approach a workout, should be looking at reviewing closely their leases and loan documents. And in this slide here, you'll see kind of an issues list of things to look at. Yeah, both parties will want to look at time and manner of performance issues as to timely performance. The second bullet point there underneath, material adverse change, material adverse effect terms. Creditors should in particular pay special attention to that to see if there's any possible covenant default there. And a borrower and tenant should focus on that last bullet point, force majeure clauses. Maybe there's some temporary excuse of performance or some other term in the lease or loan document that would provide for an excuse to not perform. And these obviously terms and conditions of all these agreements are very fact specific. So you know, at least take the time to review your documents to see maybe what your options are before proceeding with the workout. Next slide. With respect to loan documents, and if you're a borrower, you know, one of the strategies we've seen, and you're not in default yet, is you know, you can draw down, if you have an existing line of credit, you can draw down your unused availability on that line, which will help with your liquidity and cash flow needs. You know, interest rates are still low right now in this climate, but you know, take a look at your loan documents if you're thinking about doing that, and make sure that you know the request for a draw is not an affirmative rep that there's no default that will exist or will rise from the draw. And so you want to be careful when you make that draw request that that's not going to happen. And you know, if your situation's tenuous, then you know it's going to create tension with the lender too by pursuing that route. Often lenders can't really stop you from doing it, but it will just create some tension. So a forbearance is also something to think about when we're talking about workouts. Forbearances are applicable to both loan documents and leases. We'll get into specific issues of the forbearance agreement in our next webinar on June 18th. But for purposes of this presentation, forbearances are something to think about for both parties. If there's a light at the end of the tunnel here for a borrower or a tenant, if the prospects, you know, seem like that they could improve, just if the borrower or the tenant just had a little bit more time to turn things around, or as the economy ramps back up from our pandemic. So besides the obvious borrower benefits to having that additional time, a forbearance agreement also has some benefits for the creditor too. We list them here. You can build goodwill and avoid reputational risk, loss of that reputation in the marketplace. Typical term for forbearance agreements, 30 to 90 days, which is kind of, you know, what we're seeing out there in the market now, and that's true for COVID as well as prior to COVID. And some lenders, especially any loans that are guaranteed or backed by the government, like Fannie and Freddie, they've instructed their servicers to pursue loss mitigation. So there's that added incentive there for lenders to participate in a forbearance negotiation. And really, from a lender's perspective, when you think about it, forbearance is probably a better option because, right now, what's the alternative, to file suit to enforce your rights and remedies under the loan documents releases. And, you're looking at evictions and foreclosures, and with the courts, slowly coming back online, you're looking at probably July before you see any sort of meaningful progress in your case. So it's something also that kind of incentivizes the lender and creditor to pursue a forbearance agreement. So, all right. I think that's the end of my topic.
Yeah, thank you, Steve. All right, we're going to shift gears again. I'm going to spend some time talking about dissolutions. I mentioned before, a Chapter 7 bankruptcy is a liquidation and termination of the business. Another way to do that, to accomplish that, is a dissolution. A dissolution is a procedure that's conducted pursuant to state law, and it's handled by the debtor and the officers of the debtor and their attorneys. It requires shareholder approval, of course. 2/3 is a minimum requirement. But if you have that, and you can dissolve the company, and it's all handled, privately in a more private procedure. With the dissolution, once it's approved by the shareholders, they would also approve a plan of liquidation. And similar to the bankruptcy, it's the obligation of the officers to liquidate those assets and try to build up an estate for the benefit of those creditors. Now, similar to the bankruptcy, if there's a lien on those assets, those creditors who hold the liens would have superior rights to that particular asset, and that would not be part of that estate, that liquidation. How are assets to be distributed? Well, that's part of the plan of liquidation. I mean, sometimes creditors could receive a particular asset. Sometimes an asset could be distributed to a shareholder. So that's part of the liquidation, how a particular special asset is going to be handled. But again, creditors have a higher priority to shareholders, and shareholders do not receive any distribution of assets until the creditors have been satisfied. The other concept, dissolution, winding up the business affairs. As I mentioned before, with the Chapter 7 bankruptcy, it's the trustee's job to wind up the affairs of the business. It's the trustee's job to try to collect any outstanding receivables and just take the final steps to wind up the affairs of the business. With the dissolution, those steps are handled by the officers of the corporation and through their attorneys. And part of that wind up would be filing final tax returns for the Internal Revenue Service. Another part of the dissolution is notification to various governmental agencies. If a company is going to be dissolved, many times they may have a license with the state of Illinois or other governmental agencies. But part of that dissolution process is notifying the IRS that the company no longer exists. That's kind of important because if you don't make that notification, the IRS will be contacting you and asking for unfiled tax returns. So you want to make sure they're on notice that the company no longer operates. Same thing with the Department of Revenue, IDES. And then, as I mentioned before, if the company has a state license or a federal license, you're going to want to notify those agencies that the company has been dissolved. Once the articles of dissolution have been processed by the Secretary of State, then your attorneys would notify those creditors, and those creditors have a period to file their claim with the attorneys for the debtor. Similar to a bankruptcy, if a creditor files a claim and that claim is not legitimate or is for a higher amount, then you can reject that claim. Of course, if you reject the claim, that creditor then has a right to bring a suit in order to enforce that claim. Now, one important concept here is that you're shortening the statute of limitations. So once you send a claim to the creditors, if they file a claim, you object to that claim, that creditor has 90 days to file a suit in order to enforce that claim. If they don't file in a timely manner, then their claim may be forever barred. Involuntary bankruptcy, let's talk about that a little bit. if you have 3 or more creditors and they get together, they could force a company into bankruptcy by filing a petition on behalf of that debtor. So that could happen. If there is, if creditors feel that something shady is going on, that the assets are being absconded by the owners, by the shareholders, or improper treatments happening, those creditors could get together, force that business into a Chapter 7 bankruptcy. And then if that happens, the Chapter 7 trustee would be appointed and he would jump in, take over, and handle the liquidation of that company. Now, I mentioned be careful of fraudulent transfers. Again, that could be one reason that the creditors force you into bankruptcy if they feel that prior to the dissolution, certain assets were improperly transferred. That would give that trustee that ammunition to go after those parties who were the benefit of those fraudulent transfers. Okay, at this point, I'm going to shift gears. As I mentioned before, you may be involved with the business. Maybe you only have problems with the IRS and all your other creditors have been taken care of. They're current and they're timely, you're up to date with all those other creditors. In that case, you may want to consider other non-bankruptcy strategies to deal with that problem. So I'm going to turn it over to Josh. Josh, go ahead.
Thanks, Ted. So as Ted mentioned, I'm going to be talking about employment taxes, mostly in reference to the IRS, but a lot of this goes for state employment taxes as well. When you're dealing with businesses that owe employment taxes, because most small businesses and most of our client base are pass-through entities, meaning they don't pay income taxes. If a business does have a substantial tax liability, most often it's going to be from unpaid employment taxes. And the big thing that businesses and especially business owners have to keep in mind is that when a business owes unpaid employment taxes, there's something called the trust fund recovery penalty that the IRS is going to address, and it could be pretty problematic. Now, most business owners know that when federal employment taxes are paid, there's 2 parts to it. There's the employer's portion of the employment tax payment, which is half of the FICA amount, and the employee's portion, which is the other half of FICA, plus the income tax that gets withheld from their paychecks. When that employee portion does not get paid, the IRS can hold certain individuals related to the business personally responsible for paying that unpaid amount. And when they make that assessment, when they hold normally an owner responsible for paying the unpaid employees' employment taxes, that is called the trust fund recovery penalty. So if you ever hear that term, you know that's what that means, an owner or an individual getting held personally responsible for unpaid company employment taxes. Now, obviously, this is one of the few times that an individual can be held personally responsible for a company debt. Normally, you form a corporation or an LLC to avoid personal liability, but this is one way that the IRS in the state of Illinois can go around that corporate form or LLC to hold an owner personally responsible. And one thing to keep in mind in the theme of bankruptcy, when somebody is assessed the trust fund recovery penalty, that liability is not dischargeable in bankruptcy. So bankruptcy is not going to resolve your personal liability for your company's unpaid employment taxes. Now, just getting into the process of this assessment of this trust fund recovery penalty. Once employment taxes go unpaid, there's going to be an IRS collections agent who, A, is in charge of trying to collect that debt, but B, they're going to conduct an investigation to determine who related to the company can be held personally responsible. So the question is, who is it? Who can be held personally responsible? To be held responsible, an individual must meet 2 requirements. First, they must have been responsible for paying the taxes on behalf of the company, meaning that they were the one in charge of making sure the company got those taxes paid. And there's a lot of factors the IRS will look at to see who was responsible for paying the taxes. But some of the things they'll look at is what was the person's title within the company? Were they an officer? Were they a director? Were they a shareholder? What involvement did they have in the payroll process? Were they in charge of running payroll? Obviously, the more responsibility you have for payroll, the more likely it is you're going to be held personally responsible for paying any unpaid taxes. Did you have the authority to sign checks? Did you have authority to determine what creditors were paid, be it the IRS or somebody else? And those types of things. Often, if an individual is an owner and they had the ability to sign checks, the IRS is as a default rule, just going to try at least to hold that person personally responsible and leave it up to that person to fight and say, no, I shouldn't be held personally responsible. And the law might say that that's not enough. Just being an owner and signing checks isn't enough, but That's normally all the IRS needs. That's all the boxes they need to check to at least look into trying to assess that trust fund recovery penalty against you. So that's the first factor, responsibility. Second, the individual must have willfully failed to make sure those taxes were paid. So just being the person in charge of paying the taxes is not enough. You also have to have willfully failed to pay the taxes. And under IRS laws, under IRS rules and guidance, a person has acted willfully if he directed payments to creditors other than the IRS knowing that taxes were due. And a lot of times what you'll see is a company paying what they call net wages, meaning they pay payroll knowing there's not enough money there to withhold taxes and pay them to the IRS. If somebody in charge of payroll authorizes that, paying net payroll, that's enough. They're probably going to be assessed the trust fund recovery penalty because they had that responsibility and that act is willful. And one thing to keep in mind is there's no limit to how many people the IRS can assess this trust fund recovery penalty against. It can be one person, it can be 10 people, as many people as they find that have that responsibility and acted willfulness, they'll assess them. And when they do that, each person assessed is what they call jointly and severally responsible with the company for the payment of the taxes. Meaning, if $100,000 are owed and 10 people are assessed this penalty, they don't each get a $10,000 liability. They don't get 1/10 of it. Each person in their own capacity is responsible for payment of the full amount, and the IRS can collect it from whoever they want and whatever amount they want to get that full $100,000 collected. Now, obviously, that's kind of the summary of what employment taxes are, what the trust fund recovery penalty is. But the question is, once you have this type of debt, how do you settle? Unless you're going to pay your IRS debt in a lump sum, taxes generally are going to get paid in one of two types of plans. The first one is an installment agreement, which is generally a long-term payment plan where you're paying the taxes over time. And the second is an offer in compromise, which is the IRS's settlement program. Talking about installment agreements, like I said, when you get into an installment agreement, you're getting into a payment plan where you're going to pay your tax liability generally in full over time. There are certain types of payment plans where the statute of limitations expires before the taxes are paid in full, in which case maybe you can get out without paying the full amount. But most of the time, if the IRS thinks you can afford to pay in full over time, they're going to have you do it through a payment plan, and you're going to pay it before that statute of limitations expires. If you owe if the business owes over $25,000, normally to get into a payment plan, you're going to have to provide the IRS with a detailed financial statement and supporting documentation. They're going to want to see what your company earns, what it spends, what its assets are, what its liabilities are, basically a full snapshot of its financial position. And then in determining what monthly payment amount is acceptable under that payment plan, they're really going to look at what you earn, what you spend, and the difference is going to be what they expect you to pay each month through the plan. The good thing about being in a payment plan is once you're in a payment plan, a hold is going to be placed on most collection action against the company. So the IRS isn't going to get into the company's bank accounts and pull money out. It's not going to levy its income sources. It's mostly hands-off, though they will file a federal tax lien even when a payment plan is in place. So that's something to be aware of. So in terms of like I said, the pros of an installment agreement, it's a relatively simple process compared to an offer in compromise, which we're going to discuss next. And it puts a hold on all IRS collections other than lien filings. The downside is generally you're not going to save any money, which businesses that have tax debts are often looking to do. You're still going to have a lien filed against the business, and the more you owe, the more complicated it becomes. For small liabilities, you might be able to get away without providing much financial information, but if you owe, especially if you owe $25,000 or more, and the more you owe, the closer the IRS is going to look at it, the more documentation you're going to have to provide. What a lot of people want to talk about is that offer and compromise settlement program, because that's one of the only ways to save money with the IRS, and there are big savings there if you're in the right position. So an offer in compromise, like I said, is a settlement of your liability for less than full payment. But to qualify for an offer in compromise, first you have to prove to the IRS that you or your business don't have the ability to pay your balance in full over time by selling your assets and entering into a long-term payment plan. In determining whether you can afford to pay in full, the IRS is going to look at that same sort of financial information that we discussed when talking about installment agreements. And unless there's exceptional circumstances, the IRS is not going to even consider a settlement offer if it believes it can collect in full. If they think they can get paid in full, their position is why it would be forgiven. Now, if the IRS agrees that you can't pay in full over time, that's when a settlement becomes available. And what you have to do is determine what the acceptable settlement amount is. And that settlement amount really is a function of the equity in your assets and your net monthly income for the next year or two, depending on how you structure your offer. Again, it comes down to what's in that financial statement that you provide the IRS, which they're going to review with a fine-tooth comb. And they're going to make sure everything in it meets their standards and lines up with the documentation you provide them. One thing to keep in mind about an offer in compromise, it's really irrelevant how much you owe once you prove to the IRS that you can't pay that amount in full. Whether you or whether your business owes $100,000 or $1 million, if your financial statement shows that the IRS can only collect $50,000 over time from your income and your assets, that's the offer amount. It's more of a function of what you can afford to pay than it is a function of what you owe. So if you come to the point where you and the IRS agree on an offer amount, once that amount is paid, the remaining liability is written off. That's where the savings are. And the IRS generally cannot revoke an accepted offer. So if you file an offer in compromise, or your business files an offer in compromise and it's accepted, the day after that, you win the lottery or your business comes into a bunch of money, that offer is still in place. That doesn't change the circumstances. The only exceptions to that, or the main exceptions to that, are if the IRS determines that you gave them fraudulent information in the course of the offer and compromise process, or if within 5 years of the offer being accepted, you run into another non-compliance issue, meaning a return doesn't get filed on time or a liability does not get paid on time, then the IRS can undo the offer, reinstate the liability that was written off, and obviously that's kind of a disaster scenario, so it's something to avoid. When you're paying an offer in compromise, there's generally two ways you can structure the offer payments. Under the first option, you pay 20% of the offer amount down when you file it, and the other 80% is due within 5 months of the offer being accepted, assuming it is accepted. Option B, you take your offer amount and you chop it up into 24 monthly payments. You make the first one when your offer is filed, and you continue making those all the way through the offer process until all 24 monthly payments have been made. And if the offer is accepted in that amount, once that amount is paid, again, the remainder is written off. If the offer is not accepted, the payments you've made throughout the offer process are not refunded to you in most cases. They'll be credited against what you owe, but you're not going to get those amounts back. So you got to be careful the way you structure your offer, so you're paying in hopefully as little as possible until you know you're going to get an offer accepted. So the good thing about offer and compromises, you can save a lot of money if the circumstances are right, and it's going to resolve any type of tax, penalties, and interest that you owe, other than certain types of restitution. So unlike bankruptcy, where the trust fund recovery penalty can't be resolved, in an offer and compromise, any debt basically can be resolved. The downside is it's a long process. It normally takes 8 to 12 months under normal circumstances. With everything slowed down right now, I would imagine it's going to take even longer. It's somewhat unpredictable because it depends on how the IRS views your financial circumstances. And as you can imagine, they're not always going to agree with you on the financial condition of your company. They may think things look better than you do. It's not available to everyone. If you're making too much money or you have too valuable of assets, an offer in compromise may not be an option. And especially in the case of businesses, it's just a more difficult process for businesses than it is for individuals. Because from the IRS's perspective, they can put a business out of business. They can't really put an individual out of business. So they're just more skeptical of accepting offer and compromises filed by businesses. And then lastly, a successful offer and compromise can be undone by future non-compliance. So there is some risk there, even after an offer has been accepted and paid, that your liability is going to be reinstated. A couple more things to keep in mind when an offer and compromise, when someone has been assessed the trust fund recovery penalty, the IRS can only collect the taxes one time. So again, assuming there's a $100,000 debt and the IRS is responsible for it and you personally are responsible for it, it's not as if both of you have to pay $100,000. The IRS can only get paid in full once. So if they collect $100,000 from the company, your liability is going to go away, and vice versa. If they collect $100,000 from you, the company's liability is going to go away. That being the case. So basically, when either side makes a payment against that tax liability, which again is the employee's portion of employment taxes that goes unpaid, when either side makes a payment of that, the other one is going to get a dollar for dollar credit. So a lot of people get assessed as penalty and think their liability, them and the business together, all of a sudden doubled. It's not really the case. It's just more pockets that the IRS can collect from.
Hey, Josh, thank you. We're going to turn over to the last topic, which is the assignment for the benefit of creditors. As I mentioned earlier, if you have questions over any of these topics, please feel free to type in your question at the Q&A prompt at the top of the screen. Steve, go ahead and tell us about the assignment for the benefit of creditors.
Thanks, Ted. So an assignment for the benefit of creditors can probably be best understood as an informal out-of-court liquidation process. First bullet point here is kind of a definition I lay out. So delivery and acceptance of a written voluntary transfer of a business's assets to a fiduciary who is known as an assignee, into trust for the administration and distribution of proceeds to the payment of debt. It is an express trust that's created by the documents. Unlike other states which have statutes that govern assignments, here in Illinois it's governed by common law. One of the benefits of an ABC is that creditors need not consent. Upon the delivery by the company of its assets and acceptance by the assignee possesses the assets and therefore it becomes outside the reach of creditors. Next slide. So here we have kind of the advantages and disadvantages of the ABC. As I mentioned, it's an out-of-court liquidation process, so therefore it's going to be, or can be, less expensive than a Chapter 7 bankruptcy case, which is also focused on liquidation. And as a result, it could result in larger and faster distributions of proceeds to creditors. So for that reason, creditors, may often go along with it. One of the other benefits is that the company can choose a professional assignee to act, whereas with Chapter 7, you're kind of stuck with the whatever bankruptcy trustee is assigned to you. The disadvantages, because it is out of court, there's no court-ordered discharge of the debt, does not stay any actions against the business or its assets, there's no bankruptcy automatic stay provision. And again, it's not a reorganization, it's a liquidation, so the business will not continue. Next slide. So here's sort of a comparison of the assignee versus the bankruptcy trustee. Like the bankruptcy trustee, the assignee is a fiduciary under a fiduciary trustee of the express trust created by the assignment document. His powers and duties are to collect and administer the assets and distribute the proceeds to creditors. Unlike a bankruptcy trustee, there's no court approval required for a trustee or for an assignee to act, and so unlike the bankruptcy trustee, the assignee doesn't have to run to court for everything it wants. Next slide. The assignment. So the assignment is also called a trust agreement with respect to an ABC. Again, it has to be delivered and accepted by the assignee. And a key factor, a key feature here is that delivery and acceptance by the assignee must happen before the company, the debtor, receives any citation to discover assets or post judgment collection proceeding. That's an important feature in order for the ABC to be valid and effective. The trust agreement will lay forth the powers and duties of the assignee, which are pretty typical of a trustee's duties under common law. All the property of the company must be conveyed, not just a portion of it. And then the assignee has to act for the benefit of all creditors, not one particular creditor or class of creditors. Next slide. So similar to a Chapter 7, there's a sort of a process here for liquidation. You'll see here that the once acceptance is made by the assignee notifies the creditors and other parties of interest, and it will list those here, to request claim submissions. The assignee liquidates the assets, reviews the claims, and distributes the proceeds accordingly. Those proceeds are distributed to secured creditors in order of their lien priority. Second, to the assignee's cost of administration. And often with ABCs, they're going to be working with, the assignee works closely with the secured creditor with first lien priority. Often that's a bank with a blanket lien on all assets. And so they'll work closely with that bank, that secured creditor, to ensure that the priority of payment, and also work with the assignee to establish a budget for the cost of his administration and to make sure that the assignee gets paid. Then behind the assignee's cost of administration, we have other creditors' claims for taxes and unsecured credit. Next slide. So that wraps up the ABC portion. Ted, I'll turn it back to you.
Okay, thank you, everybody. Okay, so at this point, we are going to take on questions from the members of our audience. So one question, I want to go to Tim Hughes. Can you comment on the right of creditors to go after other parties who may have signed personal guarantees in connection with it, in a Chapter 7 proceeding? Can you comment on that?
Sure. A creditor that can go after not only the debtor, but once they file bankruptcy is stayed, there's only a co-debtor stay in a Chapter 13. So creditors can go after anyone who signed a personal guarantee, and even in a Chapter 13, that co-debtor stay is effective only as to consumer debts. So if that debtor owned a store and had signed a loan or a lease with a personal guarantee or a mortgage on that store, and the bank is foreclosing on the store, the owner's filing of an individual Chapter 13 stays all his creditors, but for that commercial lender.
All right, thank you, Tim. And I would also add a point of clarification. In a Chapter 7 bankruptcy, there is no discharge of debts. Chapter 7 bankruptcy for a business, the business no longer exists. It terminates the existence of that business. Unlike a personal Chapter 7 bankruptcy where you do receive a discharge normally. So taking that concept, because in a Chapter 7 bankruptcy for a business, there is no discharge, creditors still have those claims that for any party who signed a personal guarantee, those claims would survive a bankruptcy, Chapter 7 bankruptcy of the business. So we have another question here related to this. This goes to Steve and Tim. Why would anybody choose a Chapter 7 over an assignment for the benefit of creditors? What factors would lead you to the more formal and expensive process?
And you want to start, or shall I?
Why don't you go first, Steve?
All right, so I think the answer lies in a couple of different slides that I laid out. But basically, it's an ABC is not a court supervised process, so you don't have a discharge of debt. It doesn't stay any action against the company, so that'd be a reason why you want to go with a Chapter 7. And see what else. Also, if there is, like I mentioned, if there's already is post-judgment collection proceedings, then you can't do an ABC anyway. So, Tim, anything else?
Yeah, I would just say, depending upon the nature of the creditors, that sometimes a 7 is simpler, easier, and gets the finality done easier than an ABC. An ABC requires that assignee, the contract to be agreed upon, and a Chapter 7 is prepare the documents, make sure there's not any surprises in the filing to guarantors or management or insiders, but depending upon the nature of the creditor, a 7 could be more advantageous than an ABC.
Yeah, I'd also add that a Chapter 7 is a procedure that is much more readily known and understood by creditors. They see a business files a bankruptcy, they typically understand, okay, they're out of business, they don't exist anymore. ABCs are much more uncommon, and for that reason, same with the dissolution for that matter, a creditor may not understand that, and they may continue to harass and contact the debtor or the debtor owner. So that's another reason why bankruptcy may be advisable, just to avoid that confusion. Next question is for Josh.
Actually, Ted, let me just add,
Yeah.
with an ABC, I think a good scenario for an ABC would be there's very little in the way of post-collection proceedings, obviously, and just litigation in general. And where I see an ABC often occurs, where there's the possibility of an assignee entering into an asset purchase agreement for substantially all the assets of the company, to be able to sell all the assets to another buyer and maximize proceeds, and have that buyer be kind of a stalking horse. You go out, you take that APA, and you kind of test it in the market, and assuming that the stalking horse buyer is still the highest and best offer, then the APA can proceed, and then the assignee would be essentially the seller, take those proceeds and apply them to the debts.
Yeah, what you're getting to is just a strategy to try to acquire a business and just strip it from its liabilities. So that's a strategy that can be considered. Next question, Josh. If a business settles unpaid employment taxes through an offer in compromise, and I say business, a company, does that resolve the individual owner's trust fund liability?
Good question. The answer is no, it does not. When any individual or business goes through an offer and compromise, that offer gets accepted, that only resolves that individual or business's specific liabilities. So if a business goes through an offer and resolves its liability, whatever it pays in that offer may be credited against the individual owner's trust fund liability, but the rest of that owner's trust fund liability is still there and it's going to be resolved. It's got to be resolved, and vice versa. If an individual goes through an offer and gets the settlement accepted, that does not resolve the company's liability. And a lot of times what you'll see is if a company's not viable anymore, it may go through one of these processes we discussed today, Chapter 7 liquidation or dissolution. That leaves the liability for the individual. They might be able to go through an offer and compromise and resolve their liability. And then once everybody comes out the other end, hopefully that everything's been paid or forgiven. But to answer your question, short answer, no, that does not resolve it for the individual.
Okay, next question goes to Steve Magala. Steve, should lenders invoke a material adverse condition clause to stop a borrower from drawing down on their line of credit?
Yeah, that's they could. It's potentially, though, it's risky to do that because it could lead to a very upset borrower. You could really trash that relationship, and it could lead to potential litigation especially if the reason for invoking that MAC clause is not really clear, and you can end up risking litigation with the borrower. So I would counsel any lender to be very careful to invoke that clause.
Okay, thank you. Next question is Tim. In the wake of what's been going on with COVID, do you anticipate businesses using a subchapter 5 in order to try to renegotiate leases with landlords or try to reduce their rent obligations moving forward?
I believe so. Chapters or subchapter 5s allow for that ability to renegotiate with the lease, but as Steve had presented in his presentation, if that can be done informally ahead of the bankruptcy. But again, if the landlord is unwilling, the tenant taking the step of filing Chapter 7 puts a lot of pressure on the landlord to evaluate, does he want that space to go dark for maybe a long time, or does he want to work with the tenant in a reasonable modification?
Yeah, I would add that, in subchapter 5, the tenant, upon the filing of the bankruptcy of subchapter 5, I think there's going to be a discussion. I think you're going to see a lot of discussions between debtor tenants and their landlord before that decision is made on whether or not to reject that lease. And part of that discussion may be, we need to renegotiate the terms of the lease at a rate that's maybe in tune with current market conditions. And a commercial landlord faced with that prospect, they have a hard choice. They may say no, and then they run the risk of the subchapter 5 debtor rejecting that lease. in that situation, then any delinquent rent payments would be addressed through the subchapter 5 plan, but then the landlord's going to be seeing a space that, like you mentioned, is dark. On the other hand, the landlord may, if they realize that, may be willing to listen to the tenant and negotiate a new lease term, albeit at a lower rate, but they're going to have a tenant in that space. I think you're going to see a lot of landlords face that question. So I think this is a good strategy. I think you may, if that is your biggest issue, I think a debtor could even reach out to the landlord even before they file, mention that they're considering on filing a subchapter 5. And for that reason, let's start renegotiating now. So I think this is a great tool, the subchapter 5, for small businesses to leverage better commercial leases moving forward in the future in the wake of everything that's happening. Next question to Josh. Are there other company taxes that can be collected from individual owners? You talked a lot about employment taxes, trust fund taxes, but are there other tax liabilities that other owners need to be worried about?
There are, and this really comes up in any kind of tax that the company is collecting from somebody else and then supposed to be paying it to the government. So the big one is federal employment taxes. You also see that at the state level with employment taxes. The big other one is state sales taxes, where customers are paying sales taxes to the retailer, and then the retailer is supposed to pay those to the state of Illinois. If those are collected and not paid, then the state of Illinois can go after owners and collect the full amount from them. So that's the big place where you see it. There may be some excise type taxes too, but the big ones are employment taxes and sales taxes.
Okay, we have one more question. This goes to Steve. Steve, in a situation of a forbearance agreement, if a lender agrees to enter in a forbearance agreement, what happens to those payments that are missed? I mean, they're not forgiven. I mean, I guess, can you comment on what happens to those payments?
Yeah, it's also subject to negotiation between the parties. So those payments can be all back put towards the back end of the term and just added on, or maybe part of the balloon payment that's due at the end of the term, or it could be reamortized, and so your monthly payment amount goes up by a little bit each month, reamortized over the remaining term. So there's a variety of ways how that amount that's forborne really gets captured, and that'd be just subject to negotiation.
Thank you. Okay. So that concludes our presentation today. I would ask if anybody has any other questions that occur to you at a later date. By all means, don't hesitate to reach out to us. You can submit your questions at info@lavellelaw.com. In addition, if you visit our website at lavellelaw.com, you can contact any of the panelists here. If you have any specific questions you'd like to ask them, by all means, don't hesitate to reach out to us. Lastly, I would suggest and invite you to visit our YouTube page, where we have another breakfast briefs dealing with personal bankruptcies and other strategies for individuals, as well as many other topics that we've addressed in our business brief series and other series. So thank you again for joining us today, and hope you have a good remainder of your week. Thank you.